You're charged with assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. 2025 CR 003287, State versus Christopher Vincent White. Can I have parties announce?
Rick Pena for the state of Texas.
Doug Campbell for Mr. White.
And are you Mr. White?
Yes, Your Honor.
Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. White, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. We will waive the repeat offender enhancement.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen, by entering into this plea, you could be deported, not
Yes.
allowed re-entry or naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Lenea, Lenea, Laralde, Larralde. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge. With
State-
one change,
Yes.
believe Ms. Rinaldi now goes by Ms. Bland.
I'm sorry, the last name?
Last name Bland,
Bland?
B-A-L-A-N-D. B-L-A-N-D, yes.
All right. State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the BIPP, cap evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence, State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Right after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. So, with regards to this plea bargain, I don't see why I should follow the no harmful or injurious contact. Why shouldn't it just be no contact?
I can address that.
Yes.
Mr. White and Ms. Bland, who's sitting here in the front row, have had a conversation while Mr. White was in prison for the previous family violence charge.
And the previous family violence charge, was that against her?
No.
I could, no.
Okay.
But I think that change of heart has led them to understand that this is not the path that they both want to go down. They are going to raise a couple of children together, and if there's a no contact order, that's going to be a possibility.
What, are these his biological children?
They are not. They're children that she has adopted. Her
Wait, let's slow a bit. So she's adopted some children. I'm reading this police report that she had been living in a hotel from hotel with these adopted children.
Don't believe they were there.
They were not adopted at that point.
Well, that's true.
So she didn't have any children with her at that point.
She may have, Judge. I think the difference, though, is that having served his time, Mr. White and Ms. Bland are asking the court to allow them to have no harmful or injurious contact. He is on probation still for the other case.
Parole.
Parole, excuse me.
Yeah, I don't think this is a good. I'm not going to follow the no harmful or injurious contact.
Can I talk to my client briefly?
Sure.
Judge, in talking with my client and with Ms. Bland, they are okay with no contact.
All right. Because here's the thing, you have to internalize what you did. You have someone who's living in hotel from hotel. They're telling you, no, according to the police report, she's telling you, you can't stay with me. And I'm making an assumption that she didn't want you to stay with her because you were not pulling your weight, because she's living in a hotel. And then you come over anyway with your clothes, and then you hit her in the face with a Nike sandal. That's what the police report says. And she had visible redness. So it appears to the court you haven't learned anything from being in prison beforehand or being on probation beforehand with the
Judge,
previous assault.
this was before he went.
This was previously before I've been incarcerated. I've been incarcerated for 1.5 years since then.
I don't think your relationship with her would be a good one. And I don't think you would be successful on probation with that relationship. And I don't think adopted children need to be around that. So any objections? I've heard your argument. What I can tell you, your plea bargain agreement is for no harmful or injurious contact with Linnea. I am actually going to do a no contact order with her. So that is a violation of your plea bargain agreement. So do you still wish to go forward with this plea?
How long would it take to get a trial?
How long, what?
How long would it take to get a trial set?
Oh, we can do it right away.
Okay. Ready.
So
Right now?
Probably gonna be next week.
Yes, sir. Just go for it.
So what do you want to do?
Just go with the no contact. It's fine.
All right, so there's a $1,500 fine that will be probated. There's an affirmative finding of family violence. There's to be no contact.
Judge, with
Yes.
respect to the TAP evaluation, given the fact that he's been locked up for 1.5 years, can you do that without?
Let me get to that. Just give me a moment. So there's to be no contact with Linnea, Laraldi, Bland, proof of employment within 45 days, no employment as a home health care provider or with minors, no residing with minors, the BIPP course, 100 hours of community service restitution, TAP evaluation, out of custody, follow recommendations. If you miss that TAP evaluation appointment, that's going to be a violation of your probation, you understand?
Yes, Your Honor.
Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person, regular random UAs.
One other thing,
Yes.
with respect to the requirement for employment, my client does have a disability. That's-
All right, so what's your disability?
I'm MHMR, I have bipolar, PTSD, I have
Alright.
ADHD. When I have a stipulation on my parole that I have to go to special needs program, so I'll be having to do programs for that.
All right, so it's going to be proof of employment within 45 days or SSI within 45 days. MIC evaluation, out of custody and referral for Center for Healthcare Services. Probation, is there anything else? Is there anything?
The length of deferred, Your Honor?
Oh, thank you. 3 years.
I'm sorry, Judge.
No, it's my fault. 3 years deferred adjudication.
Judge, our agreement was 2. We just.
No, that's not a part of the agreement.
Discuss it.
Sure. Okay, sir. I'm just.
All right, 3 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir.
Thank you.
Thank you.
The hearing centers on Christopher Vincent White, who is facing a third-degree felony charge for assaulting a family or household member after a previous conviction. Right away, Judge Stephanie Boyd explains how serious the case is, reminding him that the offense carries a possible prison sentence of 2 to 10 years. To avoid an immediate conviction, White enters a no-contest plea and asks the court for deferred adjudication. After reviewing the evidence presented by the prosecution, Judge Boyd decides there is enough proof to support a finding of guilt. Even so, she agrees to delay that finding by granting deferred adjudication. The judge's decision, however, is far from a light outcome. She places White on strict supervision and makes it clear that there will be serious consequences. She orders a $1,500 fine, which is suspended as long as he follows every condition of his probation. Judge Boyd also issues an affirmative finding of family violence, ensuring that this will remain a permanent part of White's record and could affect him in future legal matters. The hearing reaches its most important moment when Judge Boyd firmly explains the protective conditions designed to keep the victim safe, making it clear that these rules are mandatory and must be followed without exception.